Number 9, People v. Oscar Sanders. Good afternoon.
Good afternoon, Your Honors. May it please the Court, Chase McReynolds of Davis Polk, counsel with Legal Aid Society, on behalf of defendant appellant Oscar Sanders. This was a close case where the jury deliberated for 10 hours over 3 days and submitted 9 notes. Before the jury ever finalized its verdict, the trial court committed reversible error by shackling Mr. Sanders for no reason. Today, I plan to concentrate on this unconstitutional error and Mr. Sanders' life sentence, which was the product of a fatally flawed sentencing procedure.
Let me just ask you about the shackling for a moment. It isn't 100% clear from the record the way I read it, but it seemed as if this particular judge had a policy of always handcuffing the defendants from the point in time when the jury said, returned a note saying we have a verdict, while the sentence was being pronounced. Is that your understanding of that practice there?
Correct, Your Honor. The record supports that the defense counsel objected to this routine policy by the trial court, and that's all the record
I'm sorry, counsel, just so I'm clear, I did read it as he's shackled after the verdict, right?
Your Honor, he was handcuffed.
Handcuffed after the verdict.
He was handcuffed before the jury entered the courtroom to read its verdict and before the jury was polled.
I see. So the handcuffing takes place, then the jury comes in. So he's handcuffed when the jury comes in, they read their verdict, they're polled, I understand the objections made. And that's the record we have here, in addition to Judge Wilson's indication that this is the judge's policy, right?
Yes, with one other point, Your Honor, and that's Mr. Sanders, like everyone else in the courtroom, was asked to rise when the jury entered, and that would have made his handcuffs even more apparent to the jury.
So, yeah, I was going to ask you that to elucidate that part of the record. Your position is that the handcuffs were visible during the delivery of the verdict?
Correct, Your Honor. The record doesn't reflect.
But that's speculation, right? I mean, nobody noted that for the record.
Nobody noted the visibility of the handcuffs, Your Honor, but that's not what is required for constitutional error under this court's.
But nobody said it wasn't visible. The defense counsel made that representation as part of the objection.
That's right, Your Honor.
Prosecutor didn't say, no, they're not, they're covered. Court didn't say, keep his hands under the table.
No, Your Honor. The record we have is that the court overruled the objection and in the same breath asked the jury to enter the courtroom.
Let me ask you this. Let's just go with this assumption that it is a policy. That is how defense counsel described it, and no one said otherwise. Because it's a policy, is it then subject to harmless error? Is there any argument that it shouldn't be subject to harmless error because it's a routine handcuffing, which is exactly what the court in Deck said is absolutely unconstitutional?
Your Honor, we don't argue that harmless error. Here, harmless error is a fair argument to make, but there is no harmless error because at the moment that the jury saw Mr. Sanders in handcuffs, that crucial moment, the verdict was not yet final.
Counsel, do we, and you're making a facial challenge to the policy, I take it, but do we, and it seems like the appellate division did this, it seems as if the appellate division in their harmless error analysis factored in the stage of the proceeding, right? I mean, they did, it's a polling error, it would be apparent in the polling of the jury. That's where the harm would take place, right, in the polling, because the trial's over, the evidence is in. The verdict is rendered, it just hasn't been given, so the verdict's the verdict when they walk into the courtroom. It hasn't affected the piece of paper they have. But do we do that? Should we take into account that in the harmless error analysis, that this error it would have taken place in the polling of the jury?
No, Your Honor. That was actually an argument that defense counsel brought up in the federal case, Deck v. Missouri. And
the death penalty phase.
Yes, correct. That was at the death penalty phase of trial.
And is polling an indispensable part of the process here?
Yes, Your Honor. Under New York criminal procedure law, the verdict is not final until the jury has been polled if defense counsel exercises its right to poll the jury. And so here, the people don't dispute that it was improper for Mr. Sanders to be handcuffed at that time. Rather, the people just argue that there was no error because the shackles were not visible. But as we've already been over, the record supports the exact opposite. And under this court's standard in People v. Cruz, there is enough of a record to support constitutional error here.
And is it correct here that no reason was given specifically as to this defendant of the necessity of handcuffing or shackling?
That's right, Your Honor. Although both the federal and state constitutions require a case-specific, on-the-record finding of necessity for a defendant to be shackled during criminal proceedings, that was not done here.
I think you said you also,
I'm sorry, go ahead, Judge Wilson.
I was going to move to the sentencing, but if you
Oh,
want to
no, I
continue
just
here.
have one more question then. DEC, death penalty phase of the proceeding, did they in DEC, and I can't think of it offhand, did they in DEC look at the potential error through the lens? I know they said they applied the rule. Did they look at a harmless error analysis in DEC through the lens of that particular part of the proceeding? I found it was error in Judge Breyer's opinion, but I don't recall. Did they factor into their analysis the fact that it was the death penalty phase rather than the guilt phase of that trial?
I don't,
Despite the way they came out.
not that I recall specifically, Your Honor, but there were prior, DEC relied on precedent that the shackling of a defendant in front of the jury at both, in the Holbrook case, in both the guilt phase and the penalty phase of trial is so inherently prejudicial that it should be prohibited.
Right, but there
At
still
both
is a
points.
harmless error analysis, right?
There is still a harmless error.
And that rule is an absolute one, because, I mean, you've heard the question now a couple of times. The evidence is all in, the deliberations have taken place, the verdict has been committed to writing, we presume. The only thing that could possibly be affected by the error temporally is the polling of the jury, and you're saying that that doesn't matter, you know, is the law that it's absolutely at any phase of the trial, and you don't factor in where it's happening as part of the harmless error analysis?
Yes, Your Honor. That should be, we have cases at the appellate division where only a few months ago, the third department held in People v. Kane, where the defendant was shackled during grand jury proceedings, that was sufficient.
That's the very beginning. You know, like I said, all the evidence is in, the case has been deliberated, the verdict is down. It's just polling at this point. It's hard to understand how that could not matter.
I
Let me
understand.
ask it this way, this may help you to address what I think Judge Carataro is getting to. At what point in the proceeding is the defendant declared, as a legal matter, declared and found guilty?
After the polling is complete and the judge directs the clerk to enter the verdict. So up until that point, the prophylactic rule should be that during criminal proceedings, there is unconstitutional error. And then whether or not the error was harmless is a separate question.
Was
Okay,
there any
so-
indication that during the polling, was there any hesitation on any part of any juror concerning the verdict?
The record, there may have been, Your Honor, but the record just reflects a question and answer. So I think the simple answer is no.
It seems also
So
that,
do you think that's something that we
Sorry.
should consider in a harmless error analysis?
I don't think so, Your Honor, and the reason,
Is it
may I answer the
because,
question?
is it because if they see the handcuffs, if there was someone who had a hesitation or felt that they were unduly pressured or something improper happened in the jury room, once they see the handcuffs, okay, then I was wrong, and they don't say anything?
That's one point, Your Honor, that especially here where the prosecution's theory at trial was that Mr. Sanders was prone to anger quickly and prone to physical outbursts. Seeing Mr. Sanders in handcuffs at that crucial point would have only served to reinforce the prosecution's narrative. And the other reason is that I think generally during polling, the record is, boom, 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 quick question and answer. So I'm not sure logistically if most records would ever reflect hesitation. What we do have is deliberations over 3 days, submitting 9 notes on the most hotly contested issues of the trial.
Thank you,
It
Counsel.
seems, I'm sorry, it seems like, just to finish this point, and I'm sorry, I keep going off to Wilson, but
I think we have 2 questions coming.
this timing, I thought about this. My view is your view, that the verdict isn't entered until if there's a request for polling, they do the polling and then it takes place. But it seems that you could have a ministerial requirement, and we've had them not in this context, so that officially the verdict doesn't get in, and the person may be shackled, defendant may be shackled during that. Okay, I think that'd be hard to argue that it isn't harmless, even though it's before the actual verdict is entered. But Denk, it's a death penalty phase. He's already been found guilty. I mean, guilt or innocence has been established, and they still said it was error to shackle. So it seems to be the guilt or innocence determination, and when it's lodged, can't be the determinative factor, right? It's the potential harm to the defendant, and here the argument is the harm is polling and the influence of the jury seeing him in shackles during the polling process, right?
That, I would generally agree, Your Honor, with the caveat that there are 2 prongs, as you know, to harmless error. The second being that the first being the people need to prove that there was no reasonable possibility that the shackling contributed to the verdict. The second being the evidence must be overwhelming. And here, the people cannot meet their burden.
Understood. Thank you.
And counsel had said he wanted to touch on the other issue he wanted to address was the sentencing issue, which I'd like to hear you on. And I think you can say what you want, but specifically, I think, not wanting to characterize the people's argument, but it's basically no harm, no foul here because the prosecutor put in all the evidence that the court should have put in, and so this is okay. So if you could address that, I'd appreciate it.
Yes, Your Honor. Quickly.
Summarily, yeah.
Quickly. The language of the statute itself says that the court must submit an order, give notice of that order at least 20 days before the sentencing of the factors in the defendant's background and prior criminal conduct which the court deems relevant for the purpose of sentencing. The legislature made the determination where we're talking about the potential for a life sentence that is at the court's discretion, that the defendant must go into that sentencing hearing with the full opportunity to prepare for the factors that the court has deemed relevant. Here, that did not happen. There was no order. There were no court factors published or filed, and there was no notice of the hearing even. So not only was there not substantial compliance with the statute, which is what the first department held, there was no compliance whatsoever with the statute.
Thank you.
May it please the court, I'm Philip Tisney for the respondent. In the unique circumstances of this case, there's no reasonable possibility that the brief handcuffing of defendant affected the jury's verdict.
So before we get to that, let's pick up on the points I think that Judge Garcia was making and asking of defense appellate counsel. So DEC is about the sentencing phase, and as I understood DEC was merely addressing preliminarily the question of whether or not the existing jurisprudence on the constitutional prohibition on routine shackling, physical restraints, should apply once the guilt phase is over, because the prior jurisprudence had been on the guilt phase, because the concern about the presumption of innocence being maintained no longer is at play. That is how I understood DEC, which then gets us back to whether or not we are still at a guilt phase in this case. Can you address that before you get to the whole harmless error?
Well, no, I think that's right. I think there still can be error of a constitutional magnitude in this context. I think Deck leaves open the question of harmlessness. I think Clyde in this court answers that question, but the people's position is not that there could not be categorically an error of the one that they allege occurred here. Our position is simply that if there was an error, setting aside preservation, setting aside whether it was actually seen to the jury, if there was an error, in the unique circumstances of this case, where the jury's heard all the evidence, they've deliberated about all the evidence, they've come to a decision that the evidence proves the guilt beyond a reasonable doubt.
So is polling not a significant part of the proceedings when the verdict has not even been entered until after that's done, if it's requested?
No, it's an important part, but I think it influences what we're talking about when we're talking about a harmless error analysis.
So it
Ultimately-
isn't that this is not error, assuming these other things you're assuming for this question. Your position isn't that this can never be error to shackle during a verdict, before polling, if polling's asked for. That can never be an error. Or are you endorsing a blanket policy, which this judge may have had, that a shackle during a verdict?
So I want to be careful about how I answer this. It is not the case that an error like this could never be error. There's a lot of negatives there, so I want to make sure I'm clear about that. It is possible for a shackling error, assuming everything,
Right.
yes.
In between the jury saying we have a verdict and actually reading the verdict, before they're polled. There could
Yes.
be an error in that interstitial period. So what would be an example of that?
Well, so for instance, if the court had a policy of routinely shackling defendants in the courtroom without giving any individualized explanation for it. That's, of course, what they've alleged here. We have arguments that that was not what happened here, and we think the record is not clear on that. But again, even if you
The
assume that
record is
all of
not
that is
clear
true.
on the fact that the trial judge gave no explanation whatsoever?
Well,
for-
so that this is another unique aspect about this case. The judge did give, or somebody on behalf of the court did give an explanation. There was
On the
an off-
record?
No, there was an off-the-record exchange that happened before we have the on-the-record comment by counsel, in which counsel is apparently told your client's going to be in handcuffs, and gives some justification for that, which then prompts counsel when he gets back on the record to say, I've just learned that this is because of the court's policy.
Are you asking for a reconstruction hearing then? Should we send it back? And
No, we've framed it as a failure of defense to make a proper record, and I think,
But at that point, when you're back on the record, it's the judge's court. It's the judge's responsibility to respond and make the record clear as to why, if said policy was in place, or if there was no such policy. Isn't it?
I agree. I also agree that it wouldn't be would be extraordinary to expect the people to make a record in support of an application that they haven't asked for in support of a
No,
ruling
not the
that they...
people. When the defense brings it to the attention of the court, it is the court's responsibility to respond with
Well-
respect to why are you ordering my client to be shackled? You're saying whatever happened, whatever the defense then tried to put on the record, it wasn't enough for preservation?
No, I don't want to belabor this point, because at the end of the day, this case turns on, or this point turns on harmlessness. I think perhaps what happened with this particular judge is, having just given his explanation off the record, having gotten back on the record, and having had counsel object to say, not, you haven't sufficiently articulated your justification, but having the objection be, you've articulated your justification, and I just don't think it warrants handcuffing my client, that the judge then said, okay, fine,
Why
I
was it
disagree.
harmless here?
Why was it harmless here?
Yes.
Because harmless error turns on whether there's any reasonable possibility that the error affected the verdict, and again, where the jury's already heard all of the evidence, deliberated on the evidence, come to a decision that it proves the defendant's guilt beyond a reasonable doubt, and written on the verdict form that we think this defendant is guilty.
Can we view this from
Without
a somewhat more traditional perspective? We heard about many hours of jury deliberation and many notes that were given, which I think was counsel's effort to say, The jury was really struggling with the evidence that was presented in this case. So can you speak to the overwhelming quality of the evidence of guilt, which is what I think would make the error harmless?
That's right. Well, part of traditional harmless error analysis, of course, involves an assessment of whether the evidence was overwhelming, and we think the evidence was overwhelming.
Is that one of your arguments here? that
Yes,
the
it
evidence-
is.
So tell me about that.
The main disputed issue at the trial was the defendant's intent, and the proof on that score was very strong. You had two medical experts say that this injury was inconsistent with a blunt force trauma, as would be explained if the defendant perhaps punched the defendant and accidentally cut him. You have the victim who said, I felt myself get cut when the defendant dragged his hand slowly down the side of my face, of course, which is inconsistent with an accidental injury. You have the photos, of course, themselves that show the injury, which is common sense, not something that looks like an accident. You have the testimony from multiple witnesses that the defendant's conduct was threatening and aggressive towards the victim himself, proving that he had a motivation to hurt the victim. And then, of course, you have the testimony that days before the graduation, the defendant armed himself by hiding a scalpel blade in his hat, the very same hat that he then wore to the graduation, suggesting a level of premeditation that was inconsistent with accidental injury. There was overwhelming proof that the defendant intentionally slashed this victim, and that's reflected in the fact that after the jury got all of the information that it had requested about the assault charges, that it deliberated for 2 hours and came back with the unanimous verdict on both of those counts. So no, I mean, I think there is a way to conceive harmless error analysis in this context that doesn't require a finding of overwhelming evidence, but make no doubt, the evidence was overwhelming on
Yes,
this
as
point.
I understood your argument on the harmless error, it sounded to me like a per se rule. Once the jury has reached a verdict and announced to the clerk or whoever, or the officer, whoever is available to them, or sent the note to the judge saying, we've reached a verdict, and it's done. You can shackle someone, and that is completely harmless because the jury has made its decision.
No, and I think here the defense...
And I
and-
misunderstood you because I thought that's where you were
No,
starting. Okay.
and let me be clear, I think the defense and the people agree here that prejudice in this context really is measured by whether there's a realistic possibility that any juror was considering recanting their vote to convict.
But that's illusory. No one can ever say that. You're not going to be able to say that. That is an insurmountable burden on the defendant
I think,
for what is considered
No.
unconstitutional conduct
Your Honor,
by the court.
I disagree. I agree that would be an extraordinary case. I agree that those are rare cases, but there are things that happen in trials all the time which suggest extraordinary levels of juror dissent.
At the
here.
trial, but actually walking in and being able to say, I think that, what are they going to do? Go to the jurors afterwards and say, when you saw the handcuff, did that change your mind?
They could.
Did that affect you?
They could. They could,
Is that a
the jurors could have
How
sent
is that a
notes out.
workable rule, rather than making clear that you can't have this kind of policy? And so the court erred, and it is not, well, first of all, I don't actually think harmless error applies to this. I think that once you have a policy, it strikes me as very odd to argue for harmless error. Harmless error applies in individualized circumstances. But even on the harmless error, it's just an unworkable rule.
I think the court...
That rule, that doctrine does not exist for something like this.
So let me emphasize first that this is a very rare set of circumstances. This is a very limited, I mean, sort of, courtroom restraints are rare
Yeah.
as it is. This is a very sort of unique type of courtroom
Except for a judge who
restraint.
has a policy.
Well,
Doesn't that make it easier then to decide the case? Since
Well,
it's
but Judge,
so
and-
rare,
and here's where
it will
preservation-
not affect many judges or many cases.
Judge, here's where preservation, I think, is a real problem. It's not even so much a problem for the parties as I think it's a problem for the court, because I don't think you know what the court's policy is. You know,
Well, it must have been this one. You're saying there was an off-the-record discussion, and then counsel comes on and says, I've just learned it's a policy, and the judge doesn't say anything.
but it could just as easily have been, and I agree that I'm engaging in speculation here, but it could just as easily have been where the defendant has an extremely long and violent criminal history, where he is accused of a violent act, and where, if convicted, is facing a very long prison sentence, that yes, in those circumstances, I have a policy of requiring a defendant who has not been
But
handcuffed throughout the...
again, it is the judge who controls his or her courtroom, and it is a judge's responsibility to so state that under the circumstances of this particular case, that is the reason of what happened, and we just simply don't have that
But wouldn't
set
your
forth.
reason,
Fair enough, Judge Troutman, and my point in making that speculation is just to say if this court is poised to write a decision about an unconstitutional policy, I don't think there is a record for you to say anything
but wouldn't your
definitively about a
record-
policy.
Your record that you just gave us always apply in a death penalty phase? I mean, what could be worse than that? The person's looking at a death sentence. This person may be looking at life, but why would then there be, you per se have a rule in death phase cases, which we don't, that you can shackle because, wow, stakes are high, the person's been convicted and they're may be executed.
Well, no, defendants commit death-eligible cases as their first offense. It's not, it is possible.
Recidivist death, and recidivist?
So, and I'm not foreclosing that in some other case, I'm not suggesting that if the policy that I've speculated could have existed in this case was in fact the policy that the court had, that our office would defend it or say that it was not error subject to harmless error review. All I'm saying is that we don't know what the policy is, and so if this court this court is not in a position to write anything definitively about what the court's policy is, and that is at least partly a reflection of defense counsel's failure to make a record, and as well, of course, the court's failure to articulate its record on the
I think that's
reasons.
fair, but what I would take from your point about we don't really know, right, what a juror might have done had the defendant not been in shackles, maybe would have done exactly what the juror did, which is to say, that's my verdict, or might have done something different. Unless there's a operational concern of some sort, wouldn't it seem better to you, given that uncertainty, to require the statement on the record of why you're restraining a defendant in that interstitial period? Make that the rule, right? Make sure the rule applies to that, because then you would eliminate that uncertainty. You would either have a statement from the court that could then be reviewed for its reasons, or you would have no restraint, in which case you wouldn't have the uncertainty because the juror wouldn't be affected by that.
And at the end of the day, if that were the rule, so be it, the error would here still be harmless.
Thank you, counsel.
Can I just very briefly address?
You're way over your leg. Very briefly, say what you want to say.
The only point is that the statutory purpose of 420 is to give the defendant notice of and an opportunity to contest the factors the court is going to consider when it's deciding whether to impose a PFO sentence. The people's motion detailed all those factors. The defendant fully litigated all those factors. The court relied on all of those factors. And of course, those are all of the same factors that
So
courts...
did defendant then waive this argument as a consequence of participating?
Rather than call it a waiver, what I'd like to say is that the failure of any objection shows that there was no prejudice that the defendant experienced here from what we agree was a statutory violation.
You mean an objection that there wasn't a court order? Because there was an objection. But
He said
mean
you have to order
objection
a
about the
hearing.
court order.
But what he didn't say was, and I have no idea what factors you're going to consider, Your Honor, because you've never issued the addendum to the order that orders the hearing. So there was a statutory violation, there was no prejudice.
Well, how about, which I took from counsel's point, although I maybe took more than I should have, that some part of the way that the statute is structured is to require the court to be the first to exercise its discretion about what the basis and whether there was going to be a hearing in the first place, that effectively got turned over to the prosecutor here, so that the court didn't independently exercise its discretion about whether to consider him a discretionary persistent felony offender, but effectively ceded that to the prosecutor, and you might have had a different result had the court done that initially.
I think what happened here was the court said, I think this defendant might be eligible for a PFO sentence. People draw up the papers.
Right.
I don't know how frequently this happens in the courthouse. The PFO sentence is not something that happens often in New York County or really ever, frankly. But in this circumstance, it was clear to everybody that all of the factors that the court was going to be considering in making its PFO decision were the factors that were outlined in the people's papers, litigated by the defendant, both in writing and orally, and then pointed to by the judge when he made his decision. So again, statutory error, but under this court's decisions, no prejudice, and so no new sentencing.
Thank you.
Thank you.